Johnson, any idea where Mr. Lassay went? I think we are. Have you had enough time?
We're ready.
Okay. All right, we'll go back on the record. The appearances remain the same as earlier. You've had sufficient time to prepare Mr. Cotton and Mr. Eichhoff?
Yes, Your Honor.
And the state? Yes, Your Honor. All right, so I'll call the jury in. We'll talk about objection to Exhibit 19, and then the defense will rest. The state will indicate they're not calling any rebuttal witnesses. I'll explain we already did our jury instruction conference, and I'll go into reading instructions, all but the last few, and then allow opportunity for argument, and then final instructions. All right? Anything else before we bring out the jury? All right. Please stand for the jury. Please be seated. The jury has returned to the courtroom. Thank you for your patience, ladies and gentlemen. The objection to the exhibit is sustained. Mr. Eichhoff?
Your Honor, we have no more further question of Mr. Cayer.
All right, thank you. And there was no recross of Mr. Cayer? All right. Any additional witnesses, Mr. Eichhoff or Mr. Cotton?
No, Your Honor.
The defense rests?
Yes, Your Honor.
All right. Any rebuttal?
No, Your Honor.
All right, thank you. Ladies and gentlemen, the evidence is now closed. Typically, the next step would be that I would send you out and we would have a jury instruction conference, but we took advantage of that opportunity and already took care of that. So we're prepared then for me to read you my instructions on the law, and I will read you all of those instructions except for a few brief concluding instructions that are better given after the attorneys make their closing arguments. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The first count of the information in this case charges that on or about Tuesday, June 7, 2016, in the village of Hobart, Brown County, Wisconsin, the defendant, Jacob Cayer, did cause the death of Sabrina Teague with the intent to kill that person, first-degree intentional homicide, contrary to Section 940.01 sub 1 sub A of the Wisconsin statutes. To this charge, Jacob Cayer has entered a plea of not guilty, which means the state must prove the offense charged beyond a reasonable doubt. The second count of the information charges that on or about Tuesday, June 7, 2016, in the village of Hobart, Brown County, Wisconsin, the defendant, Jacob Cayer, did cause the death of Heesun Teague with the intent to kill that person, first-degree intentional homicide, contrary to Section 940.01, sub 1, sub A of the Wisconsin statutes. To this charge, Jacob Cayer has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The third count of the information charges that on or about Tuesday, June 7, 2016, in the village of Hobart, Brown County, Wisconsin, the defendant, Jacob Cayer, did attempt to cause the death of Joel Kennedy with intent to kill that person, attempted first-degree intentional homicide, contrary to Section 940.01, sub 1, sub A, and 939.32 of the Wisconsin statutes. To this charge, Jacob Cayer has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The fourth count of the information charges that on or about Tuesday, June 7, 2016, in the village of Hobart, Brown County, Wisconsin, the defendant, Jacob Cayer, did intentionally enter a dwelling, 1368 Riverdale Drive, without the consent of the person in lawful possession of the place and with intent to commit a felony. Burglary, contrary to Section 943.10, sub 1M, sub A of the Wisconsin statutes. To this charge, Jacob Cayer has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The fifth count of the information charges that on or about Tuesday, June 7, 2016, in the village of Hobart, Brown County, Wisconsin, the defendant, Jacob Cayer, having been charged with a crime and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, bail jumping, contrary to Section 946.49, sub 1, sub B of the Wisconsin statutes. To this charge, Jacob Cayer has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The sixth count of the information charges that on or about Tuesday, June 7, 2016, in the village of Hobart, Brown County, Wisconsin, the defendant, Jacob Cayer, having been charged with a crime and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, bail jumping, contrary to Section 946.49, sub 1, sub B of the Wisconsin statutes. To this charge, Jacob Cayer has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, as charged in Count 1 and Count 2, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present as to each count. As to Count 1, first, that the defendant caused the death of Sabrina Teague. Cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill Sabrina Teague. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. As to Count 2, first, that the defendant caused the death of Heesun Teague. Again, cause means that the defendant's act was a substantial factor in producing the death. Second, that the defendant acted with the intent to kill Heesun Teague. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, It does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. As to count 1, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Sabrina Teague with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. As to count 2, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Heesun Teague with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The defendant is charged with attempted first-degree intentional homicide in count 3. The crime of attempted first-degree intentional homicide, as defined in Section 939.32 and Section 940.01 of the Criminal Code of Wisconsin, is committed by one who, with intent to commit first-degree intentional homicide, does acts toward the commission of that crime which demonstrate unequivocally, under all of the circumstances, that he or she had formed that intent and would commit the crime except for the intervention of another person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, that the defendant intended to kill Joel Kennedy. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. Second, that the defendant did acts toward the commission of the crime of first-degree intentional homicide, which demonstrate unequivocally, under all of the circumstances, that the defendant intended to kill and would have killed Joel Kennedy, except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone but the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside the defendant's control. While the law requires that the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant intended to kill Joel Kennedy and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed Joel Kennedy, except for the intervention of another person or some other extraneous factor, you should find the defendant guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Burglary, as defined in Section 943.10 of the Criminal Code of Wisconsin, is committed by one who intentionally enters a building without the consent of the person in lawful possession and with intent to commit a felony therein. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. First, that the defendant intentionally entered a building. Second, that the defendant entered the building without the consent of the person in lawful possession. Third, that the defendant knew the entry was without consent. Fourth, that the defendant entered the building with intent to commit first-degree intentional homicide. That is, that the defendant intended to commit first-degree intentional homicide at the time the defendant entered the building. For the specific elements of first-degree intentional homicide, please refer to the jury instruction for that offense for which you have just been instructed. The intent to commit a felony must be formed before entry is made. The intent to commit first-degree intentional homicide, which is an essential element of burglary, is no more or less than the mental purpose to commit first-degree intentional homicide formed at any time before the entry, which continued to exist at the time of the entry. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all four elements of burglary have been proved, you should find the defendant guilty of burglary. If you are not so satisfied, you must find the defendant not guilty. Bail jumping, as defined in Section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of bail jumping as charged in Count 5 and Count 6, the state must prove, by evidence which satisfies you beyond a reasonable doubt, that the following three elements were present as to each count. As to Count 5, first, that the defendant was charged with a crime in Brown County Case Number 16 CF 608 as stipulated by the parties. Second, that the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. Third, that the defendant intentionally failed to comply with the terms of the bond. This requires that the defendant had the mental purpose to fail to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required he not commit any crime. The state alleges that the defendant committed the crimes of 2 counts of first-degree intentional homicide, attempted first-degree intentional homicide, and burglary. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed at least one of those crimes. For the specific elements of each of those listed crimes, please refer to the jury instructions for each of those crimes for which you have previously been instructed. As to count 6, first, that the defendant was charged with a crime in Outagamie County case number 15 CF 238 as stipulated by the parties. Second, that the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. Third, that the defendant intentionally failed to comply with the terms of the bond. This requires that the defendant had the mental purpose to fail to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of 2 counts of first-degree intentional homicide, attempted first-degree intentional homicide, and burglary. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed at least one of the crimes of first-degree intentional homicide of Sabrina Teague, first-degree intentional homicide of Heesun Teague, attempted first-degree intentional homicide of Joel Kennedy, and or burglary. For the specific elements of each of those listed crimes, please refer to the jury instructions for each of those crimes which you have previously been instructed. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. As to count 5, if you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved, you should find the defendant guilty of bail jumping. If you are not so satisfied, you must find the defendant not guilty. As to count 6, if you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved, you should find the defendant guilty of bail jumping. If you are not so satisfied, you must find the defendant not guilty. In the first phase of the trial, you have heard evidence that dealt solely with the defendant's conduct during the alleged incident. You are to determine only whether the defendant is guilty of the charges of 2 counts of first-degree intentional homicide, attempted first-degree intentional homicide, burglary, and 2 counts of bail jumping. If you find the defendant not guilty, the trial will be over. If you find the defendant guilty, the trial will proceed to the second phase, where you will determine whether the defendant was not responsible by reason of mental disease or defect. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless, in your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses, and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to decide how much weight, if any, to give to the statements. In evaluating a statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of the statements, along with all the other evidence, in determining how much weight, if any, the statements deserve. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any, has been shown. Possible motives for falsifying testimony. And all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. The defendant has testified in this case, and you should not discredit the testimony just because the defendant is charged with a crime. Use the same factors to determine the credibility and weight of the defendant's testimony that you use to evaluate the testimony of any other witness. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. During the course of a trial, the attorneys may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. Evidence has been presented regarding the defendant's concern about allegations of other criminal conduct of the defendant for which the defendant is not on trial. There is no information being presented that those other allegations were actually made or that the criminal conduct even occurred. The evidence has been presented for you to consider only on the issue of motive. You may not consider this testimony about any allegations of other criminal conduct as evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offense charged in this case. This evidence was received for the issue of motive, that is, whether the defendant has a reason to desire the result of the offense charged. You may consider this evidence only for the purpose I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense charged in this case. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. The evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. There is evidence in this case which, if believed, indicates that more than one person was involved in the commission of the offenses. The fact that the other person or persons are not on trial is not material. You are to determine only whether the defendant, Jacob P. Cayer, is guilty or not guilty. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. As I said, ladies and gentlemen, those are my initial instructions. There are a few brief instructions that I'll give you after the attorneys make their closing arguments. For those of you not familiar with this procedure, because the state has the burden of proof, Mr. Lassay will make his argument first. Then Mr. Cotton will argue his case, and then Mr. Lassay will have a chance to present rebuttal argument. Mr. Lassay? Okay, Mr. Johnson?
Ladies and gentlemen, I just want to tell all of you right up front, thank you for your patience during the last 3 days, and most importantly, your attention. I know it's a strange thing to be masked like this. It's more difficult, but we appreciate your patience and attention. When this case began, Mr. Lassay told you in the opening kind of what to expect to hear, just an outline of the evidence. And I think Mr. Lassay talked about a horror movie, but unfortunately it's not a movie. And when I began, I thought about what a horror movie involves. A horror movie basically is very disturbing and scary, graphic, brutal. There's usually killing and involves weapons a lot of times in these movies, knives or other weapons. When the movie ends, you can turn on the lights, shut off the TV, and it's done. On June 7th of 2016, at 1368 Riverdale Drive, it wasn't a movie. You can't just turn on the lights and make it stop and go away. What happened to Sabrina Teague, Heesun, or Sonny Teague, what happened to Joel Kennedy was real. Make no mistake, it was a real horror, what happened. It involved still killing of two people, two human beings, an attempted killing of another human being. It was still just like a horror movie, brutal, graphic, involved weapons, involved a tire iron and a knife. A lot of blood, there's DNA and a confession. Ladies and gentlemen, I'm going to use a PowerPoint that's going to be up on the screen just to help as an outline as I go along, but I want to talk to all of you directly. Go to the next one, Dave. There's different elements or parts of the crime, and first-degree intentional homicide up on the screen has just two parts, two elements, and that is the defendant, in this case Jacob Cayer, caused the deaths of both Sabrina Teague and Heesun or Sonny Teague. Okay? That's number one. Secondly, that Mr. Cayer acted with intent to kill Sabrina Teague and Heesun Teague. Those are the only two elements. The next crime, two elements to attempted first-degree intentional homicide, involved Joel Kennedy. And that is that Mr. Cayer intended to kill Joel Kennedy. Second, that the defendant, Mr. Cayer, in this case, did acts towards the commission of the crime of first-degree intentional homicide, which demonstrate unequivocally, under all of the circumstances, that the defendant intended to kill and would have killed Joel Kennedy, except for the intervention of another person or some extraneous factors. For example, in this case, it can be other factors like medical people attending to him, him running away from the scene, him locking himself in the bathroom, other factors like that. Otherwise, the elements are all complete. That's why it's charged as an attempt. The next crime is burglary. And I know most of you don't think of this case as a burglary type of case, right? You might think, well, what, burglary? Most people think of burglary as breaking or going into somebody's house without permission and stealing. In this case, burglary is also, number one, that Mr. Cayer intentionally entered that dwelling, entered the house. Okay. Number two, that Mr. Cayer entered the dwelling without the consent of the person in lawful possession. Obviously, in this case, that fits when he broke in through a window and committed these crimes. And that, of course, that he knew, Mr. Cayer knew the entry was without consent, obviously. And then this part, the defendant, Mr. Cayer, entered that dwelling with intent to commit first-degree intentional homicide. And that is that Mr. Cayer intended to commit the first-degree intentional homicide at the time he entered, when he went in, when he went through the window, that's what he intended to do. Okay. And finally, the elements of the crime of bail jumping. In this case, you heard that Mr. Cayer was charged with a crime in 2 separate files, and then he was, number 2, released from custody on bond, and they intentionally failed to comply with the terms of the bond. Those are the parts of bail jumping. And I wanted to start off with that, just at the very beginning, to just outline those are the parts of these crimes. Next, the evidence. I don't know exactly what the defense is going to argue here, but I anticipate that there's not going to be a lot of argument that somebody killed intentionally Heesun and Sabrina Teague. And again, I think it would be absurd if there's an argument that somebody didn't intend to kill them. Okay, and that's based just even looking at the injuries involved. Number 1. Okay, I think the argument, again, I think is going to be that Mr. Cayer isn't the one that did this, but I anticipate you might hear that somebody intended to kill them based on these injuries. Okay, no doubt at all. And I'm going to go through. You heard the autopsy information from Dr. Vincent Tranquita. He does a good job. He did a good job, I think, of explaining everything, going very slowly, explaining it, even though it's very graphic to have to hear those things. He did the autopsy first with Sabrina. And Sabrina had stab wounds, actual stab wounds to the cheek. You remember hearing about how it actually, from a stab wound to the cheek, actually injured her tongue. A stab wound to the chin, to the torso area, a stab wound to the base of the neck, a stab wound by the left side of her clavicle, a stab wound in the middle of the left clavicle with injuries to her ribs, her lung, the sac, the pericardial sac that goes around the heart, and the aorta. There's a stab wound of the sternum, which injured her sternum, her rib, that's lining around the pericardial sac around the heart, and actually injured the right ventricle of her heart. There was a stab wound, the middle area of the abdomen, that went into her liver. There's a stab wound to the left side upper part of her back, a stab wound to the right side, more the middle of the back, and a stab wound to the left side lower part of the back, which went and damaged her kidney. There's no doubt at all that there was intent to kill here, just based on those injuries. One of the stab wounds you heard about, and in a moment, I'm going to warn you, I'm going to show you some photographs in a moment. And one of the stab wounds was labeled, you'll see it, letter E. E is in Edward. And that stab wound was like on her right side, upper part of her chest, and that one went down, so it went down, and went all the way into her heart from over here. There were more than just stab wounds. You heard about incised wounds. Remember how the doctor explained an incised wound is more like a cut almost on the skin. It's not as deep as it is length. And he described incised wounds to the head of Sabrina, to the neck. I think you remember that one. There was a bad incised wound to her neck, gaping on the side of her neck. There was more than that, too. There was blunt force trauma There was abrasions to her head, to her torso. There was contusions to her upper extremities, like her arms. You know, he described upper extremities. I refer to them as arms, from your shoulder to your hands. And then finally, the doctor indicated that as a result of everything that he had reviewed, the autopsy and all of his review of everything, that there was no doubt about cause of death. It was stab wounds to the head and torso. And then the manner of death is homicide. Again, there's no doubt at all that this is an intentional homicide to her. Just based on that, on the injuries, on the multiple injuries. Can we go to the next one? I'm going to show the photo of Sabrina. You can see those stab wounds that I just talked about on the torso area, to her face, the one that went into her cheek, into her tongue. You can see that one that I talked about that's up towards kind of above in the right part of her chest. I think it's number letter E, and that went all the way to the other side where her heart was too. And I had to go in a downward motion. So, the next slide I'm going to show you is another one you saw during the trial, and it's a close-up of that letter E, that wound, the stab wound I should call it, and it shows you what happened, the injuries to Sabrina. And then finally, the next photo were the stab wounds to the back that I just talked about, that Dr. Tranquita described, and also that significant incised wound to the left side of her neck that you can see in that photo. Okay. Next, you heard about the autopsy to Heesun, and I'm going to call her Sunny. And so Sunny, which most people called her, there can be no doubt at all that there was someone intended to cause her death. Okay. I want you to just look at the injuries that were described to her, that happened to her. Again, stab wound, actual stab wound to the head, to the scalp area. Torso stab wound to the left breast area, injuries to the left breast, rib, pericardial sac around the heart, and actually damaged her heart, that stab wound. Incised wounds, we described earlier. Actually, a part of her ear, her left ear was cut off, it looked like. Incised wound to the left side of her forehead, to her left cheek, to her jawline. Neck injuries. Remember the doctor described the neck injuries. He described like a furrow around her neck. A furrow is like a line or like a small ditch area, they call it. A furrow sometimes is a ditch area. It's a furrow from a ligature, from something like a rope or a cord that could be used when someone is strangled. In addition, the doctor talked about that there was indications that there was 2 ways that she had her neck damaged. From that rope, but there was also evidence of manual strangulation. So when you actually use your hands, for example, when somebody's that angry and that out of control and to strangle somebody, there was damage, he talked about, to the different strap muscles on the neck. It's more consistent also with strangulation with the hands or something manually in that way. That blunt force trauma to the head, and then finally, the fractures to her skull, her nose, her jaw, her sternum was actually fractured, ribs, her spine, and her fingers. I mean, there can't be any doubt based on that someone intended to kill her with those injuries. And the doctor went through also all of the different, and I'm not going to go through all that again today, the different abrasions on her body, to her head and neck, contusions to her head and neck, lacerations, torso abrasions, contusions, the upper extremities, arms and legs, abrasions, contusions, the right upper extremity, again, extremities all over her body, basically all over her body, contusions, lacerations. Remember the doctor even said that at one point she was hit so hard to the head, it fractured her, like the orbitals, the part around your eyes, and another part in her skull too, the lower part of the skull as well he talked about. There was a different part of the skull that was fractured besides the frontal areas. Now, at the end of his testimony, I asked him, what's the cause of death? And he included stab wounds to the torso, blunt force trauma to the head, torso, and extremities, and compression to the neck. And he described it in two different ways. Manner of death, homicide. So both causes of death are both of Sabrina and Sonny, and also the manner of death in each one, for both of them were homicide. Now I started with that to just get that out of the way because, again, I don't think you're going to hear that there was any doubt. I think the defense is, that somebody killed them and intentionally killed them. But I think the defense is it wasn't Mr. Cayer. Okay. The other thing, I'm going to show up one more photo. This photo is of Sonny. You already saw it. You know, to prove cause of death, sometimes we don't know what was used to kill somebody. And in this case, it's pretty clear what was used to brutally beat and over again Sonny. And the best illustration, unfortunately, of that is this picture that has the circle. And you can clearly see, like, from the rounded end of the tire iron. And then you can even see, if you look like we did in court earlier, the close-up, inside the circle, the kind of straight edges of the hexagonal shape that you would normally use a tire iron to take off, nuts on the car wheels or something like that. And then also, you can tell that the doctor said this was consistent, this tire iron being used, obviously, because of, remember he talked about the crescentic shape? Sometimes you don't have a complete circle like that, but some of the injuries on her body or head had that half shape, where you might have the end of that tire iron, for example, that had the circle on it, hitting in a way that would cause the crescentic, or like a crescent moon shape. So with Sonny, it's not only clear that somebody intended to kill her and did kill her because of the injuries. It's very easy to prove in this case, and the evidence shows that there was intent to kill. But also, it looks like there was two different weapons probably used with Sonny. There was stab wounds, and there was also the blunt force trauma as well. Next, you might not have this in some cases, but in this case, the state has an eyewitness who saw what happened. And Joel Kennedy was there, and he described how he worked that evening at Burger King. He had his Burger King shirt on with the little insignia, the round circle. It becomes significant later because it's consistent with Mr. Cayer remembers. And he had his girlfriend Sabrina pick him up at work eventually. And they went to Walmart. He said life was good and that for he and Sabrina, things were looking good, looking forward for life. They were going to, I think, get some movies or something at Walmart, and they were just going to come home. Interesting to watch a movie. And they came home, and then he had to face the horror of what happened. Now, one of the things I think that was significant is that when Joel and Sabrina are at Walmart, the timeline is important as you think about this case too. And you heard about how when Joel and Sabrina are at Walmart, I think it was at 7:51 p.m., Joel Kennedy's cell phone is connecting to Wi-Fi at Walmart. 7:51. And at 8:11, there's the 911 call. So that's the amount of time from 7:51 to 8:11. And of course, they had to drive from Walmart to this house in Hobart. And you can kind of also tell that for the timeline, if you back up, the timeline when Sonny went to that celebration for cancer survivors at the Rock Garden. And then she left there. She met her friend Kathleen Zeitler. And they hug before she leaves. And that's the last time Kathleen Zeitler saw her friend. And she said she left at about 7:35 p.m. So that's about the timeline when Sonny would have been driving to her place in Hobart. So again, I don't know what the defense is really going to be about here, but I don't know if they're going to say somebody else did it. It sounds like if they're going to try and say that Joel did it or something. But Joel, if they try and say Joel did it, first of all, Joel's got not just a poke to his arm. You saw that injury. He's got a stab that goes all the way through his arm and into his chest. And Joel would have had, if he, I know it sounds probably absurd based on the evidence, but Joel would have had, I guess, when he got back to the house from sometime between 7:51, but he would have to, drive with Sabrina to the house, and in between whenever he got there, whether it took him 10 minutes to get to the house, he would have had maybe 5, 10, 15 minutes to kill for no reason Sonny, and then kill his girlfriend who he's just coming home with to watch movies for no reason, kill her too. And I don't know, again, what the defense really is. I guess I heard Mr. Cayer said that Joel was, I don't know if they're saying he was
I'm going to interpose an objection at this time. The state can discuss the evidence as it came in, but making commentary about what the defense will be, I think, is inappropriate for closing.
Well, that's exactly, I think, what's appropriate for closing, Judge. And I only get to talk in the myself personally in the closing. Mr. Slay is going to handle rebuttal, but I can anticipate defenses, and I believe that's appropriate. Okay. So if they don't argue that, fine. But if they, again, absurdly say that Joel did it because he was in with some other people or something, I guess Joel, I don't know why, he's got a big hole through his arm and into his chest. So it's absurd based on the evidence. I know everybody knows that. So show you the next screen, and I just wanted to show you that injury to Joel again, to Joel Kennedy. You can see the injury going through his arm. He's part of some thing here part of something to do something. That's what happened to him. You can see the wound to his chest and his arm. It's not a little poke. Okay. And the evidence doesn't stop there. Okay. You have a confession. And you have a very, very lengthy confession. Okay. And one of the things that everybody needs to be clear about too, confessions come in different ways. Sometimes we do it in writing. It's easier to do it in writing if it's real short. And sometimes you have audio or video, so that way you can hear it if it goes to trial. And so in this case, there's a very, very lengthy confession. And you got to see and hear how this came out. I think that's kind of important, because Zachary Holschbach and Nikki Yankee, both of the Sheriff's Department at the time, they're not yelling or screaming or trying to get Mr. Cayer, you did this, didn't you? Let's talk about that. Sometimes you see stuff like that in the movies. You get to see how they treated him. Very, very polite, and talked to him very nicely. And in that case, Mr. Cayer was willing to keep talking and talking and talking and talking. for hours. And some of the things he said are important because they're corroborated by things that are at the scene that you wouldn't know unless you did it, and were there, first of all, and did it. I mean, he provided the map. He drew the map himself. And he put right on the map that he drew and signed his name on it, on where things happened, drew the house, drew the 3-stall garage, put where you could probably find the knife. Not a big and again, we find the knife where he says it was. And then where Sabrina would have collapsed, the fence, you got to see the pictures. It's also important about how what's important too is it's fortunate that these sergeants didn't know a lot about the crime scene. Because then sometimes somebody can say, oh, you fed him that information, didn't you? You as a police officer, you told him this is what happened. These officers really didn't know a lot of information. Remember at the beginning, they didn't even know the names of people. And so they start to talk to him, and he admits to being, again, consumed with rage. And he describes it, Mr. Cayer, him, as a wave of hell. Consumed by this kind of anger. Okay? That's the way Mr. Cayer describes himself when he's leaving his house at night. Now, Mr. Cayer today said something about leaving his house the day before, or the night before this happened, and I guess he thinks there's 24, 27 hours of time missing where he doesn't know what's going on or he's missing. I think that one of the things, when you come into a courtroom, we have all these rules and we have laws. One thing is we use our common sense still, right? I think I talked to you about that when we were doing voir dire. One of your best tools is just common sense. And he left his house at night after he got in an argument with his dad, and his mom was crying. And apparently he believes that he's been wronged in a lot of ways by the world or by 2, 3 women involved in his life. And he leaves there with that wave of anger, the wave of hell, and gets on his bike and puts on his headphones and starts listening to some music called Hollywood Undead as he's biking. And I'm sure that anger was building and building, and he described it so we can know what's going on in his head. Remember, he described it was like, I tried to keep the key in the cage, but the key, I must have got out. Like his anger got out, like he tried to hold it in, but he couldn't. It's very disturbing hearing how he describes his anger that night. What he then goes on to describe is no officer mentions to him names of women or things like that. At one point, we played audio clips to give you an idea of some of you could hear his words. And he brought up Sabrina Teague. By he, I mean Jacob Cayer. And he said one time, you heard the audio, I never mentioned her, Sabrina Teague. I don't care to talk about her. She's a piece of shit. That's what his words are. She's trying to blackmail my family. She said I hit her or raped her. And goes on to say something at the very end, she needs to shut the fuck up. Those are his words that he said. Now, remember as they went through the interview, sometimes Sergeant Holschbach would play along with his, try and remember, and Jacob would say different things. I see blood. I see cement or things like that. And Sergeant Holschbach one point told him, try and remember. And he said, again, it was like a wave of hell. It was sadness, fucking everything. It's the anger. You can see the anger in the injuries. I was biking. I was thinking about how much I'd done. And Sergeant Holschbach said, Mr. Cayer, why are you angry? And again, this is his response. Because of women treating me like shit. That's what he said. as I went on in the interview, talked about different things. Talked about seeing trees at one point. And then again, Sergeant Holschbach didn't know, like he told you, about a window and things like that as a point of entry to the house. And then Mr. Cayer would, at least supposedly, he said he could be acting. He was saying, I remember a window. And then Sergeant Holschbach would say, what about the window? Tell me, Jake. And then Jake would get a disturbed look on his face. Sabrina's bedroom. I remember the wood in the bedroom. And he said, I attacked Sabrina. Eventually he said, I attacked her. And he mentions a knife and saying something about a knife. It's not my blood, though. And then at one point he continues this interview and says he thinks the Sabrina incident, at least part of it, he says, I want to say it was in the garage. And again, a lot of these things are corroborated. The window is corroborated. We showed you the pictures of the window. We showed you how it had been damaged. And you can obviously see with the grass coming in, it looks like that's an entry point that Mr. Cayer broke in. Again, he wouldn't know this unless he's the one that did it. I don't think people kidnapped him or something, or whatever his word was for it, and then pushed him through the window, broke the window and shoved him through there or something. It's absurd, right? Absurd. He just is going along telling you what he remembers then. He remembers, I think I tried to get into a car, a Chevy Cobalt or Malibu. There's a Chevy Cobalt in the driveway. I remember the 3-stall garage. And at one point, talked to about Sonny. Sonny's a real nice lady. And he said this, it's unfortunate the way things turned out. It's just unfortunate the way things turned out. Nobody told him that Sonny died at that point or anything like that. And he said, it's unfortunate the way things turned out. Mr. Cayer said, I guess today, I was just talking about it's unfortunate when we broke up, Sabrina and I, years ago, even though I'm not mad about that anymore, but what makes sense is in the context here, he's talking about what he did. What he did to Heesun, Sonny. He talks about, again, stabbing Sabrina to the torso and neck, consistent with the injuries that we observe on her body. He remembers a lot of blood. He remembers the plant, the foliage, where the knife was, drew the map, talks about where Sabrina would be located, talks about the fence, it's over by where the knife was. He talks about the bathroom. Again, the way he wants to describe it is, I remember red in the bathroom. And he remembers a chopping motion in the bathroom with another weapon, though, he said. Not a knife, not a hammer, but something like a hammer. I remember that, he said. In this case, we know what he used, the tire iron. He goes on, he recalls a hammer or something like it. He says, well, no, I remember in the bathroom, some other object like that. And then he goes on to remember things like, yeah, I remember my bike. I remember I biked over there. And he said he describes even the color, I think, of the bike. He remembers it's a gray and red bike, I think, and he describes it like a hybrid street bike, kind of mountain bike. You can find them, again, everything. You can make a list of all the things he says that are corroborated. The bicycle, the window. You can go item by item. There's so many. The red blanket. How would he know about a red blanket unless he was inside there and doing this? He said, I remember a red blanket, and I threw it to cover up blood. And you get to see pictures of the red blanket right outside the door where he came out. He jumped out of there, came out of there in that laundry room area. He remembers suddenly, I remember a shovel. Remember I got hit with a shovel, and I think in the face, he thought. Yeah, I see his fat lip that he had, too, as well. He remembers washing his feet in a white sink. And they said, well, why are you washing your feet, Jake? Because I just remember they were a mess. There was so much blood on them. Well, we find the socks in the sink, right next to where Heesun is in the bathtub. And there's the socks in the sink. It's a white sink. You saw that picture of it. You don't have to make assumptions. Okay? You can use your common sense and look at all the direct evidence and find the truth. He even talked about, this is disturbing too, it's like, this is like a horror movie, that he turned the shower on. He thinks he turned water on in 2 showers, but remember when the police came in there and you could even hear it on the body cam, that when they got there, the shower is actually running where Sonny is, and so is the sink. Yeah, he's right. He turned both on. He remembers even, he described it, a hacking motion in the bathroom. Again said, but not a knife. He remembers his shoes he wore. His DC shoes. Remember we saw those DC shoes, a kind of unique D and kind of C symbol kind of together. I think they were on the tongue of the shoe. You see them in Sabrina's bedroom down the basement, right where he came through the window. Then he says he remembers there was a guy. He later says, I think it was a male. He's the shirt guy. And there was a symbol. And he acts like he's continuing to remember it. A symbol. And it was a round oval. And I think it was either Burger King or Subway. Or something, and a kind of shirt like you'd wear when you just got off of work. Well, yeah, we know who that was. We've got a picture of Joel Kennedy's black Burger King shirt with the round oval. This is Burger King. I told you, you can go down the list and you can talk about what's on his confession and then see the corroboration from the scene, from the bicycle, the window. I attacked Sabrina. Obviously, you can see the attack on her. Something happened with her in the garage. You can see the blood in the garage. See the blood all over. Remember by the lawnmower and all over there? Stabbed her in the neck and torso. Of course, we can see where he stabbed her. She fell outside by the grass. The shirt that Joel was wearing. The chopping motion that we find out later was with a tire iron. The color of the bike, the water running, the red blanket, the shovel, the washing of his feet. You can go on and on to show that what he's saying is what he did based on the corroborating evidence that we find. Some of the physical evidence. We find the knife. We find the tire iron. We find the bicycle. His clothes look like they're covered with blood. His jeans, shoes, socks. He's got some weird mask that I showed to him that he said it's not his, that apparently had on around his neck at one point when they took it off him with eye holes in it. And then what do we find on his person? We find Sabrina's phone on him. He's got Sabrina's phone. He's got some weird kind of cord. It looks like a rope-like item that he has that was taken off his person. And then his backpack. Okay? I mean, duct tape. The tire iron's got duct tape wrapped all around it. And so does that hammer. Zip ties? These are things, zip ties he's carrying with him to this place. And we've happened, by weird coincidence, I guess, according to Mr. Cayer, I bet, that the zip ties, we also find zip ties in the bathroom next to the tub where Heesun was brutally killed. Knives, gloves, ropes. And we know it, well, he admits that's his backpack, and we have his driver's license in the backpack, too. That's just some of the physical evidence. But then the evidence doesn't stop there. So besides having confession and all the physical evidence and an eyewitness, we've got DNA evidence. Okay. The tire iron, Cayer's DNA, and Heesun Teague's DNA with the tire iron. The tire iron has Cayer's DNA on it, and Heesun Teague's DNA. The knife that we find outside, the one, he identified it, he said where we would find it, has Sabrina DNA, as you saw that picture of the knife. It's just covered with a red substance. That's Sabrina's DNA on it. Okay. And Mr. Cayer said, you'll find the knife over by the foliage area, by that fence. Cross the driveway. And on the palm of his own hands, Sabrina's DNA on the palm of his hands. And it's good that you got to see, we got to see different views of those hands of Mr. Cayer. Remember when the scene nurse was talking to him, I don't know what happened at that point, but we showed you a video of when he first got there. Remember that video? There was no sound. They took his hand and turned it over, kind of had his fingers and kind of put it down. I think it was Sergeant Yankee when she was doing that. You get to see what looks like blood all over his hands. Sabrina's blood on his hands, it looks like. The shovel, he remembered the shovel, Mr. Cayer did, and it's got Joel and Sabrina's DNA. Again, if the defense wants to argue something like, well, there's not Mr. Cayer's DNA on it, well, it looks like there's a red substance on the shovel, and doesn't that make sense that there would be blood of Joel Kennedy on it? Mr. Kennedy had been stuck through the arm. You saw his injury. He runs out to the garage to get the shovel. Of course, it makes sense there's going to be some of his blood on it. Mr. Cayer, you got to see his injuries, or I guess lack of injuries. His fat lip is what he got. And it probably makes sense, too, that Sabrina's DNA, it's a shovel from the garage at their residence. But it's significant that Joel's is on there. Looks like his blood's on there from his bleeding all over the place. You saw he said he had to run way to the side, I think, or way away from the house. When you come out of the garage into the garage from inside, he had to go way over, he said, to get this shovel. And you saw like a trail of blood, remember, right inside the overhead doors where it would come up if you pulled your car in, blood going way over there to the side. So finally, when you look at all of the evidence, ladies and gentlemen, it's almost like a mountain of evidence. And there's no really other conclusion using direct evidence, circumstantial evidence, common sense that points to any other conclusion about what the truth is happening here based on the evidence. That's Sabrina Teague. That's Sonny Teague. Now, after you heard all the testimony of the witnesses, the videos, the audio, the autopsy reports, the map of the scene, the DNA evidence on all the objects, looked at the tire iron, the knife, the backpack, the contents, the bicycle, the items he had on his person, his confession. There is no doubt. There's not any reasonable, there's no doubt at all in this case based on the evidence. And there's only one verdict for all that makes sense for all of these crimes. And that is Mr. Cayer is guilty of everything he did that night and of every crime he committed to these people.
Mr. Cotton?
Good afternoon, ladies and gentlemen. I wanted to start by thanking all of you for paying close attention in this case and for being such good jurors. We know what kind of an inconvenience this is whenever you get called in for jury duty. And we started this case by asking that everybody pay very close attention. And I hope that all of you did pay very close attention. I agree that what happened that night to Sonny and Sabrina is horrible. They certainly didn't deserve what happened to them. It's inexplicable. It's sad. I don't think there's anybody here who doesn't feel that emotion. I certainly do, and I can understand that, and I appreciate that. I think the state, I want to compliment the fact that I think this was presented in a way that allows you to see the evidence or the lack of evidence, but we didn't have to see some of the horrible pictures, and it was a horrible, horrible thing that happened here. And I don't think anybody here would suggest that there was anything other than a homicide. There clearly was a homicide that took place, and the question I think that you have to answer as jurors is who's responsible for this crime, who committed this crime. And that's why we asked you to keep an open mind all along in this case, and why we asked you to pay such close attention to the evidence, because oftentimes we don't know how the state is going to present its case. We oftentimes don't know how many witnesses they're going to call. And it's your job as jurors to sit here and evaluate the various witnesses and decide what weight you want to place on which witness. And different people, when they testify at a trial, have different motivations. Some people have different experiences. And you certainly heard from, the state talked a little bit about the autopsy, the doctor who came in here to talk about the significant injuries that happened. Some people have certain expertise, and you should consider that as also when you're listening to these witnesses. And this is my chance to summarize the evidence for you. My remarks are not evidence. The things that I say, you can accept them, you can reject them, you can evaluate how I present things. I try to be candid with you folks with how I think the evidence came in, and I hope that you can give Mr. Cayer the fair consideration that this type of important case requires. It does require a very thorough consideration of all the evidence. Now, when we go back to the beginning of this trial, it was 3 days ago on Monday when the first witness was called. You heard Joel Kennedy, and I thought some of the things that he said were important in this case. Remember that Mr. Kennedy said that Mr. Cayer had never threatened them, that there would be no reason for Mr. Cayer to be present in that home. He had never seen Mr. Cayer in that house. And I think Joel had said he dated Sabrina for about 7 months, 6 or 7 months at that point, and she had not made any comments about being fearful of Mr. Cayer, having had bad experiences with Mr. Cayer. She wasn't scared of him. She hadn't brought him up. I don't even think Mr. Kennedy really even knew who Mr. Cayer was. He might have heard I think the extent of his knowledge of Jacob was there was some sort of incident at Walmart where Joel and Sabrina had crossed paths with Jake. But my understanding of what I heard in this trial was that there was nothing violent during that confrontation, or that when their paths crossed, there was nothing, certainly nothing homicidal or anything of that nature that was exhibited by Jacob. And I do think that some of Joel's testimony was certainly inconsistent, and that's not my characterization of what happened in this case. Joel Kennedy said that. He said that when the state called him. One of the first things he said was that there were inconsistencies when he was preparing for his trial testimony. When he was working with their office, he noticed inconsistencies between what he remembered happening and what he testified to. And so I thought there were quite a few inconsistencies. We discussed those with him. All of you heard those various things. And as a general rule, somebody who is being honest about something tends not to have inconsistencies. Again, goes to our common sense. I also thought it was unusual that one of the last things he had searched on YouTube was famous last words. Of course, in this case, significant quantity of evidence was obtained. Both the Hobart Police Department, the Green Bay, the Oneida Brown County Sheriff's Department, there was considerable evidence that all these departments seized. DCI seized evidence. There were phones. There were hard drives. And Joel Kennedy's phone was examined, and his phone did show that the last thing he had searched right before this very brutal event was famous last words. I think there is a lack of intent in this case. Of course, my comments are simply my observations. I trust that all of you can evaluate the evidence carefully, but I think that there is a lack of intent in this case, that if it was Mr. Cayer who did this crime, why is the huge knife in his backpack still in the backpack? Why wasn't that knife used immediately? It was a very long knife. Mr. Cayer testified to that, and it doesn't make sense that if he's intending to go in this house and slaughter people, he wouldn't have used that knife. No gloves were used. If Mr. Cayer committed this crime, certainly doesn't appear to be any lack of preparation or planning at all not to have any gloves on. You saw that in his backpack there were in fact gloves. The state made a point of it when he was on the stand today, but he wasn't wearing that. Mr. Cayer testified, we'll get into that in a little bit, but he did take the stand and give his version of events. All of you saw the body cam video of him laying in the woods or laying in the tall grass next to the house. He certainly didn't look like somebody who was actively running from the scene or trying to resist law enforcement actively or fight with law enforcement. Those are all things that we do think guilty people would do. They'd be running away some significant distance, yet he's laying there passed out in the tall grass, appearing to be in some sort of almost catatonic condition or some sort of condition, but he certainly doesn't seem to be in the condition to be committing a murder. I think some of the things coming out of Jacob's mouth at that time are interesting too. You heard that on the body cam video, but he's not making a whole lot of sense. He's talking about Ike right away, as I recall, and there was Deputy Mueller, I think, was the witness who testified about some of the things those utterances that came out of Jacob's mouth, like, Ike, where is he? And I think the deputy even said that Mr. Cayer wasn't making much sense. Again, that's important because sometimes we do have situations where an individual is immediately telling the police, you got me, this is what I did, and they're telling the officers what took place. Here, Mr. Cayer really does appear to be in some sort of state of confusion, some sort of state of anguish. And that's consistent with the theory that he testified to and the version that he gave you folks when he testified, that really there's no reason for him to want to kill Sonny. There's no motive to kill her at all. He said she's a sweet woman. He testified to the fact that she's a sweet woman, and I have no doubt that's true. I have no doubt that her daughter was a sweet woman as well. But Jacob didn't have a motive to kill them. And that's important because even though the state, they don't have to prove a motive, but we can consider motive when you folks are deliberating and deciding what's important in this case. And I want to talk about Mr. Cayer's testimony because he did take the stand, and I discussed with all of you on Friday of last week about the fact that a defendant does not have to testify. A defendant has a constitutional right not to. All of you said you would honor whatever decision Mr. Cayer made, and I thank you for that, and I thank you for listening carefully when he testified. Jacob is not a professional witness. He's not somebody who has experience like law enforcement officers do coming to court and testifying. He's a citizen. And I think that once state had introduced some clips of the audio that took place over the course of 10 hours, but we should use our common sense and think critically about some of the things that were said in the hospital because certain things are very clear. Mr. Cayer was attacked by a dog. He was bitten on the leg. He was brought to the hospital, and he was administered ketamine, which is a sedative, it's a dissociative, it's an amnesiac. So he's administered a drug that does have those properties to it. And in the state played a few clips. If you add it all up, it's maybe, let's say, 15 to 20 minutes worth of things that Mr. Cayer said over the course of 10 hours. But I thought Mr. Cayer, when he testified, did a fair job of explaining that no, he wasn't confessing to anything at all. In fact, he's maintained his innocence throughout 4 years. He's maintained his innocence even today, and he's presumed innocent. But Mr. Cayer explained that he was making assumptions. So he was giving the police an assumption that if something happened, this is how I believed it happened. And I trust all of you heard that, and you can give that the weight that, the very important weight that I think that deserves. Mr. Cayer did explain what he is able to recall from that night. He does not have a perfect recollection. I think if he were looking to simply spin a tale, he could have gotten on the stand and he could have concocted from start to finish some version that all the holes are plugged up after he studied all the evidence, and he ties everything together and says, I remember everything, and here's what happened. But I thought he was very honest when he said, no, much of this is something I don't remember, unfortunately. I do recall being on my bike. I do recall, he used the word ganked, but we know that he means abducted. And he's describing what he does remember, which is some individual, the state in their closing said, well, what is he suggesting happened? I think if you were listening to his testimony, if they were listening to his testimony, we know what he's saying. Mr. Cayer is saying he didn't commit the crime, some other people did, and that he was abducted. He was brought to the scene. He's apparently left outside the scene or dragged through the scene and dumped there, and that's why you have his presence, and that's why you have the DNA evidence that you do. But Mr. Cayer was not under the influence of any drugs or any alcohol at all, so whatever happened to him does appear to be some sort of head injury from his abduction. That's what he's told you. Now, the chain is also off his bike. If you remember that piece of evidence, his bike is off to the side with the chain off of it. That's another piece of evidence that suggests that somehow something impacted him or he fell over on his bike, because that's the most logical explanation for why a chain would be off the bike. The state called a DNA expert today. You folks heard that testimony just a few hours ago, so I don't think I need to go into too much detail about it. But I do think the DNA evidence can oftentimes paint a more full picture of both guilt or innocence. And in this case, I think the DNA analysts cut in favor of innocence in some respects, very significantly with the shovel. This was the plastic shovel in the garage that Joel had said he took, and he smashed or hit Jacob in the face with the shovel. And yet, we didn't have any of Jacob's DNA at all on that shovel, not on the blade end or the handle end. There weren't any fingerprints at the scene, and I thought very striking, hopefully you'll think the same thing, but I thought it was very striking that when Mr. Cayer's hands were swabbed for purposes of testing for DNA, there was no DNA whatsoever of Heesun on either his right or his left hand. She was the victim of an extraordinarily brutal event. There was a lot of blood. It was a very violent incident, and yet Mr. Cayer's hands don't have any of Heesun's DNA anywhere on any of the swabs. And I think it's very significant that if he had been involved in this event, we would have expected to see some of her blood somewhere on him. We would have expected to hear that testimony. And I do think a lot of things were taken. It's very clear that a lot of things were taken, but certainly not everything was tested. In trying to figure out what happened is very important. I think it was sloppy not to test everything. I think that in the case of this significance and this importance, we should expect that everything would be tested. And the lack of Heesun's DNA anywhere on Mr. Cayer is a very significant point, I think. It underscores the fact that he had nothing to do with her slaying. There was electronic evidence in this case. You heard Mr. Cayer tell the police that it was very important to him. Among other things he said during his initial entrance to the hospital, he did ask the police to, I think Mr. Cayer was on the side of transparency in a lot of ways. It seemed to me that he's read his Miranda rights. He's told he can remain silent. He's told that he can choose to talk or not talk. He waives those rights and chooses to talk to the police. He made that decision. But what Jacob was saying was, please, by all means, search my phone. Search the USB drives that I have. Examine my Facebook page. Examine my Google drives. And I think all of those things, the inference I think you should draw is that Mr. Cayer's interest in having law enforcement examine all of those things is further evidence of his innocent involvement in this case. That he's the guilty person, I would suggest, would be on the side of hiding evidence and concealing evidence and denying permission to search one's blood, refusing to make a statement, refusing to give turn over Google drives and USB drives. And yet, Mr. Cayer immediately at the very first moments is saying, please examine those things. And there isn't a signed confession either. The state talked about there's different types of things and there's different types of statements. You remember one of the exhibits early on was Joel Kennedy's written statement. Law enforcement had a written statement from Joel Kennedy signed by Joel Kennedy. Similarly, they don't have that from Mr. Cayer. I think the inference one could draw is that if law enforcement thought that Mr. Cayer was confessing, truly confessing to have committed these horrific crimes, that I think, given how open he was about take whatever Google Drive you want, search whatever you want, I would think that you would simply type up the confession or write out the statement and give it to Mr. Cayer to sign if that's truly what you thought he was saying. If you really thought he was admitting to his involvement in all of this, I believe the next logical step would be, okay, let's write it out and can you sign it? They had him draw a picture of the house and the state's made a big deal about that, but he'd been to the house. He dated Sabrina years and years ago, so the fact that he knew the layout of the house or knew that there's 3 garages or knew that she had a bedroom downstairs, I really don't think that's as significant as the state is trying to make that sound. And again, they're asking you to draw inferences. Well, when he circled a particular area, that means you were chasing her through that area. But I don't remember hearing that statement played to you. Again, your recollection controls. If I missed it, I missed it, but I don't recall that specific statement being played to you. And I don't think that what Mr. Cayer was really saying during this 10 hours of ongoing discussion was that I committed this crime. I think the history of this case has shown, and I think his position has been unyielding, that he didn't commit the crime. And I don't think guilty people offer up all that evidence to police and do the things that he did. Now, as the judge indicated to you just shortly before the state began their presentation, the state's burden is to prove this case beyond a reasonable doubt, which is the highest burden in the land. There are other burdens in the law that are much lower burdens and much easier standards for one to meet, but proof beyond a reasonable doubt is the absolute highest burden that exists under the law. And I think we read all of you filled out jury questionnaires, and we were able to learn a little bit about all of you before the trial, and we appreciate that because all of you said that you would follow the law. And the most important thing to us throughout this case has been ensuring that we have a group of people that will follow the law. The law requires a verdict of not guilty if the state has failed to meet its burden. And we think that they failed to meet their burden for all the reasons we've set forth here. And we trust that you'll reach that conclusion on all counts. Thank you.
Thank you, Mr. Cotton. Mr. Lassay?
Thank you, Your Honor, and I reiterate what Mr. Johnson said. Thank you for your attention here today, and what Mr. Cotton said as well. We appreciate that you have participated in this process to this point, and I apologize that you have to hear one more person thrown on. But because we have that burden of proof, because the state has an obligation to prove each element of these crimes beyond a reasonable doubt, we go last. We have an opportunity to have the last word, to rebut whatever it is that the defense presents to us, and to ensure that you have a full and complete understanding of this case and you can be prepared to enter what, in my view, in this case, is the only possible verdict. I applaud Mr. Cotton for doing the best that he can with a case that he was given. Didn't talk a lot about the specifics of the facts in this case because there isn't a lot to talk about from the defense perspective. This case involves a mountain of evidence supporting conviction. When on earth do you have an eyewitness, a defendant found on scene covered in blood, 15 to 20 items of physical evidence corroborating everything that the defendant said in a recorded confession, and the defendant's DNA on the murder weapon? This case is cut and dry. It is as clear as it gets. It is proof beyond a reasonable doubt and then some. Any suggestion from Mr. Cayer that he was ganked, kidnapped, or abducted by some random people and brought to this scene and just happened upon a death scene is absurd. It is offensive to your intelligence, and it has no place in a court of law. Maybe he can tell his story on Google. Maybe he can tell his story on Facebook or to whatever kind of cable network he can get on to hear him out. But that has no place in a court of law. In a court of law, we base our decisions on facts, on evidence, on reason and logic. And none of those support anything in this case other than guilt beyond a reasonable doubt to all counts. When I heard Mr. Cotton mention in his closing a few things, I want to touch on those. He talked about Joel Kennedy and Joel's testimony and talking about some of the inconsistencies in Joel's testimony. You'll hear jury instruction 300, which is credibility of witnesses. And you can assess which witnesses are telling the truth. And that jury instruction outlines for you with specificity what credibility of witnesses should entail. 1, whether a witness has an interest or lack of interest in the result of this trial. Joel Kennedy's only interest in the result of this trial is that the person who stabbed him through his arm into his chest be held accountable for his conduct. Mr. Cayer has every interest in the world in lying to you here today. He wants to go home. He wants to be acquitted of these horrendous offenses that he's committed. The witness's conduct, appearance, and demeanor on the witness stand. Ask yourself as you compare Joel Kennedy to Jacob Cayer, whose demeanor was more truthful? Whose conduct on the witness stand was more appropriate? The clearness or lack of clearness of the witness's recollection. Jacob Cayer himself told you he doesn't remember a darn thing from June 6th until he wakes up in the hospital. He has no recollection, according to what he said on the stand here today. None. So whatever he said here today about the events that happened that night, completely incredible. Joel Kennedy remembered to the best of his recollection, and were there some minor inconsistencies? Absolutely. What does a person do when they're confronted with their inconsistencies? A truthful person owns up to those inconsistencies. He says, yeah, I noticed this in my statement, but this is what I remember here today. And that's what Joel Kennedy did. What does Mr. Cayer do? He gets defensive, he gets argumentative, he gets angry, he flips off the prosecutor. There's no credibility to Jacob Cayer, none whatsoever. What about the opportunity for the witness to observe and know the matters testified to? Joel Kennedy was right there. He knows exactly what happened. And the physical evidence, again, corroborates Joel's own testimony. Mr. Cayer talks about a poke going in Joel's arm and a tiny amount of blood. Why didn't Joel just get up and, I would have stayed on top of him and hurt him. He put a knife through his arm into his chest. He intended to kill him. And Joel Kennedy got his arm up. And that butcher knife went all the way through his arm and into his chest. And there's blood all over the floor, completely consistent with what Joel talked about. And then ask yourself another factor, the reasonableness of a witness's testimony. How reasonable was Mr. Cayer's testimony? That some random individuals with whom he has a feud kidnapped him, carried him around in a car for a few days, dropped him at a scene, and killed 2 innocent people and tried to kill a third? For what? To get back at him? That's an absurdity. There's no reasonableness to his testimony whatsoever. Likewise, there's no reasonableness to his testimony here today that all of the specific details he provided in the course of an 8-hour interview with law enforcement are now somehow inaccurate. When what do we know about that confession? And Mr. Cotton says, there's no signed confession. Why would you need a signed confession? You have 8 hours of recorded video. You have Mr. Cayer stabbing and demonstrating his stabbing on a recorded video. Why do we need a signed confession? We know what was said. And I know that they want to ask you to draw suppositions from the things that weren't presented in court. You aren't supposed to draw suppositions from things that aren't mentioned in court. You're supposed to rely on the evidence that is presented to you. Did you hear anything about Jacob Cayer's G Drive, Google Drive? Did you hear anything about Jacob Cayer's Facebook page? Did you hear portions of the video? Are there portions of the video that you didn't hear? If you didn't hear about them, you don't draw conclusions about them. You don't know whether Jacob Cayer's hard drive or Facebook page, all of which he mentioned, is a public profile. You can't draw a supposition that that would be helpful to Mr. Cayer. If it was helpful to Mr. Cayer, why wouldn't they have played it? It's a public profile.
Appropriate.
I don't believe it's burden shifting when he specifically argued that we failed to show it information that was testified to as being open to the public.
So it mischaracterizes my argument.
I'm going to overrule the objection.
And my point isn't that they contain one thing or the other. My point is you can't draw a conclusion about what's on there. Don't assume that we intentionally withheld information like Mr. Cayer says. That's absurd. We presented to you a streamlined case based on overwhelming facts supporting his guilt. We presented to you the important information that you needed to know to make the decision that you can make. You are logical, reasonable, intelligent people who know that an eyewitness, a confession, physical evidence found on scene on Mr. Cayer's person and by the crime lab and the DNA corroborating his signed statement and his eyewitness. That's all you need. That's all anyone would need. That's more than anyone would need. This burden of proof, we own this burden of proof. We live by this burden of proof. It is absolutely a pillar of the criminal justice system that we must prove each element of the offense is beyond a reasonable doubt. But a reasonable doubt is not a doubt based on guesswork or speculation. It's not a doubt that arises on sympathy. I don't know how you feel about Mr. Cayer and how he testified here today, and whether you're concerned about his condition or frankly, I don't want you to do it based on sympathy for the victim either. But a reasonable doubt is not a doubt that may be used to escape the responsibility of a decision, and you have a difficult decision on 2 counts of intentional homicide and a 3rd count of attempted homicide. You are to give him the benefit of every reasonable doubt, but you're not to search for the doubt. You're to search for the truth. And you can only find, it's not a reasonable doubt unless it's based on a reasonable hypothesis consistent with the defendant's innocence. And there's no reasonable hypothesis presented to you. None whatsoever. The only reasonable hypothesis is that Jacob Cayer turned 1368 Riverdale Drive into a modern-day, real-life horror story. His wild, unsupported conspiracy theories that fly in the face of overwhelming evidence supporting his guilt have no place in this courtroom. They belong in a fictional horror story, not the real-life horror story that he created. As Mr. Johnson detailed for you, and I won't dwell on too many of these things, but Mr. Cayer's statement includes all of this information that the law enforcement officers had no way of knowing at that time. And I know he wants to tell you that this was all me getting fragments and pictures of my mind, and I couldn't see and I couldn't understand, and I was all just guessing. You were guessing on the location where you were at, Teagues' residence. You were guessing on the manner of entry into Sabrina's bedroom. You were just supposing that you were swinging a hammer-like object in the bathroom. You were supposing that maybe you turned 2 showers on because the shower was on and the water was on. You were supposing that there was blood everywhere, as there is. You were just guessing that you were washing your socks and your feet in the sink, which is a perfect explanation for why there's no DNA on his feet, why Heesun Teague's DNA isn't on him. He's washing it off. Washed his feet in the sink, washed his socks in the sink, washed his hands in the sink. Before he committed the second murder, didn't have a chance to wash it off before law enforcement got to him the second time, because thank God Joel Kennedy survived and called the police, and they were able to get to the scene where they found the murderer on site, covered in blood. He was guessing that he stabbed Sabrina and that she fell in the foliage and that the knife was right there by the driveway. It's just his supposition that there was fighting in the garage and he was hit in the face with a shovel, and we find a shovel in the garage amidst all this blood and chaos, covered in blood. It's supposition that he was trying to get into Sabrina's car, and we find the bloodstains on the handle and on the car. That there's a red blanket, that his bike is on scene. This isn't conjecture or supposition. This is a person who maybe doesn't want to own up to his own actions. Doesn't want to admit to himself that he had that anger, that his anger boiled over, that it came out, that he was that jack-in-the-box ready to explode, riding to that scene on his bike in anger, in hell, just as he described it. And that anger and that hell, that unloaded on Sabrina Teague and on Sonny Teague. You saw those crimes, you heard those injuries. It's horrific, and I'm not going to detail them. I can't. But those were done by an angry, angry human being. Someone who had gone through hell, whose anger had welled up, who could no longer control themselves. They had to have their anger come through. That was Jacob Cayer. And all 6'3" of Jacob Cayer, as he likes to describe himself, came down with that knife. Imagine the force necessary to take that butcher knife from the top of Sabrina's chest down into her heart.
I'm gonna object at this point as being beyond the scope of rebuttal. So they're just giving a second closing. It's not rebutting anything I said.
I'm almost done.
I'm going to allow him to continue and finish his argument.
That is intent. That is intent. Intent to kill by a man with so much rage and so much anger, just like Jacob describes for all these people that have wronged him. Dylan, Wendy, Nicole, Sabrina, his dad, the police, the state. We're all wrong. Everybody else is wrong. He's right. Even when his opinion isn't supported by reality or rationality or any of the evidence in this case. I ask you to carefully consider the evidence and return the only possible verdict, and that is that Jacob Cayer is guilty of all 6 of these counts. Thank you.
Thank you, Mr. Lissay. Now, members of the jury, the duties of counsel and the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 12 forms of verdict will be submitted to you concerning the charges against the defendant, Jacob Cayer. With regard to count 1, there will be one verdict reading, "We, the jury, find the defendant, Jacob Cayer, guilty of first-degree intentional homicide as charged in count 1 of the information," and another reading, "We, the jury, find the defendant, Jacob Cayer, not guilty of first-degree intentional homicide as charged in count 1 of the information." With regard to count 2, there will be one verdict reading, "We, the jury, find the defendant, Jacob Cayer, guilty of first-degree intentional homicide as charged in count 2 of the information," and another reading, "We, the jury, find the defendant, Jacob Cayer, not guilty of first-degree intentional homicide as charged in count 2 of the information." With regard to count 3, there will be two verdict forms, one reading, "We, the jury, find the defendant, Jacob Cayer, guilty of attempted first-degree intentional homicide as charged in count 3 of the information," and another reading, "We, the jury, find the defendant, Jacob Cayer, not guilty of attempted first-degree intentional homicide as charged in count 3 of the information." With regard to count 4, there are two jury verdict forms, one reading, "We, the jury, find the defendant, Jacob Cayer, guilty of burglary as charged in count 4 of the information," and another reading, "We, the jury, find the defendant, Jacob Cayer, not guilty of burglary as charged in count 4 of the information." With regard to count 5, there will be two verdict forms, one reading, "We, the jury, find the defendant, Jacob Cayer, guilty of bail jumping as charged in count 5 of the information," and another reading, "We, the jury, find the defendant, Jacob Cayer, not guilty of bail jumping as charged in count 5 of the information." And then with regard to count 6, two verdict forms, one reading, "We, the jury, find the defendant, Jacob Cayer, guilty of bail jumping as charged in count 6 of the information," and another reading, "We, the jury, find the defendant, Jacob Cayer, not guilty of bail jumping as charged in count 6 of the information." It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. Thank you for your attention, ladies and gentlemen. I think given the hour, we should at least inquire what the intention is if the jury wants to start deliberating. It's just past 6:15. Typically, we go straight to deliberations. I think things ran a little bit later than we anticipated tonight. So if you're comfortable with that, we can start deliberations. Is everyone comfortable with that, with a raise of hands? All right, it looks like everyone is indicating yes. So I'm going to ask the clerk to swear the bailiffs, and then we have another issue to address, which I'll do after the bailiffs are sworn. Yes. Swear the bailiff, yeah.
Together in some private and convenient place, subject to the direction of the court until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
So ladies and gentlemen, before you retire to the jury room, we need to address one additional issue, and that is the fact that there are extra jurors seated as alternates in this case. The jurors that are determined to be the alternates will be chosen by lot. The clerk has a tumbler with slips of paper in it with each juror's name, and she'll spin the tumbler at this time and select a name. She will do this 2 times, and those whose names are chosen will be the alternates and dismissed prior to the deliberations. The remaining 12 jurors will then begin their deliberations. The clerk will then pick 2 names.
Anthony Bino, Jessica Ostring.
All right. You can just remain where you are at this moment. I want to thank both of you on behalf of the parties, on behalf of the court, on behalf of the state of Wisconsin and the people of Brown County. I wish to express my profound thanks and appreciation for the time you've taken out of your busy schedules to be here, devoting your time to this important matter, especially during these difficult times. So I thank you for your service. To the rest of you, ladies and gentlemen, under normal circumstances, I would excuse you to the jury room to deliberate, but with the need for social distancing, that space is too small. So instead, you're going to deliberate in the courtroom. So I'm going to excuse all of you to your seats in the hallway, and that'll give the alternates an opportunity to gather their things up and leave. And then we'll take a moment to sanitize the surfaces and give you enough opportunity to have space to spread out, and then obviously we'll exit the courtroom and rearrange the seating the best we can to help you be able to be seated so that you can face each other. I want to also let you know that once the cleaning is completed, then you'll be able to come back into the courtroom, and you will have the ability to use that door and use the sequestered restroom facilities in the jury room while you deliberate. While you're waiting for this cleaning to occur, I do have to remind you one more time not to discuss the case amongst yourselves. I don't want you to actually begin deliberating until you're back into the courtroom. Please stand for the jury. Please be seated. Counsel, are there any objections to the instructions as I read them?
No, Judge.
With respect to the jury instructions, I would recommend that I just ask the clerk to place them in a binder and send them all in. Any objection to that?
That's fine.
And then obviously they'll get the verdict forms as well. What is your request with respect to exhibits? Now, one of the things I meant to mention earlier, I'm curious if there's a printout of any of the exhibits on the thumb drive, especially photographs, if those are requested.
If they ask to see them, I would like to be heard on that. I would not ask that any of them be sent back now. If they make a specific request, then I think we could address that, and we might have to come back in the courtroom and just display it as we had previously.
Or we may have to figure out how to just print certain exhibits if they're asking for that.
Could be. Depends
Do you
on what
have
they're
access
requesting.
to a color printer?
I do. It won't be as, the quality won't be as high, but yeah,
Correct, but at least it's an option for us to consider them.
it is.
So no, I think under the circumstances, given the kind of exhibits that we have, that makes sense. I am looking to limit the amount of times the jury may need to come back to us merely because they're going to be in this courtroom. However, no one else is in session. We can certainly reconvene in another courtroom if we need to address a question that they have, or frankly, we probably could have had them deliberate in another courtroom, but I think it's probably easiest just to I think we're going to have them deliberate in branch one. It's a bigger courtroom, and it'll provide more space. We don't even have to clean it. It should already be clean. And then if we have issues, we can just leave our things here. And if we need to go back on the record, we'll be able to do that from here. All right, I think that would be easier. And that's just on the same floor, so easy enough. All right, anything further we need to address right now? I would just ask that you only be maybe 5 minutes away and leave a cell phone with the clerk. All right?
Yes, we
Thank
need
you.
to address the Ken Robbins issue, Your Honor.
Do we need to address that now? Should we
Well, I
wait
need
to see
to-
what
yeah.
the verdict is?
Yes, because he's in Madison, so we need he needs to cancel his appointments if he has to come in person, so we need to address it.
Is the state stipulating, as was implied earlier?
It's
I mean, I don't know when we're even going to be done with deliberations, much less what the verdict's going to be. So we may not be done. They may break and deliberate tomorrow.
I know I'd like to give him direction whether he should be here tomorrow morning or not.
I don't know that I can tell you that, even if it's, if we're going to be ready for him in the morning or not at this point. I think
Right.
we're going to have to wait to see what happens with the jury. But
Okay.
what's the state's position?
Your Honor, the state would agree to stipulate to that if we get to that point, that Dr. Robbins could testify a video. My concern, I think the department concerned the last hearing,
Okay.
itself is stipulated that I was concerned, given the importance of the doctor's testimony, that that's not just a stipulation the council made. Mr. Chair was even at that hearing, that he stipulated
Well, I'll again express my concern that we have asked many, many people from the public who have even less of an interest in this case than Dr. Robbins could possibly have. I mean, they have no interest at all to come to the KI Center. We summoned in, 100 people? We have had members of the public sit here through the trial. We've had how many witnesses paraded on the stand that all had to be present in person. So it seems a little unreasonable to make such a special exception for one person who is scared of coronavirus when everyone else, regardless of what their position was required to be here in person. That's my concern.
Okay.
But if the state doesn't have an objection to it, and if Mr. Cayer is agreeing to it, I guess that's the stipulation you can all enter into, and I'll accept that stipulation.
So then I'd have just a housekeeping matter, Judge. I know when we've done pre-trial.
Well, are we still working on that issue? Because I haven't heard from Mr. Cayer yet.
Oh,
Yeah, I'm good with what's going on here, so.
I'm sorry?
Yeah, I'm good with that, and being on video if it needs to be, so.
Okay, so you're comfortable with Dr. Cayer appearing to testify via video instead of in person?
Dr.
Dr. Robbins.
Yeah, anything to save time.
Well, time isn't really all we're after here, Mr. Cayer.
I'm giving
This is a
everything up to the news anyways,
significant.
it's all good.
Okay, it's a significant issue, and you lose the benefit of the jury seeing him in person. Whether that plays to your favor or not, I have no idea. I don't know if that's going to be an advantage or a disadvantage for you. But I want you to understand the issues and make sure you're making an informed choice. Have you talked to this at length with your attorneys?
Yeah, it's not going to negatively affect me. So
I'm
good.
sorry?
It's not going to negatively affect me. I'm okay with it. He can appear by video. That's what I want.
All right. Any additional colloquy you want me to ask Mr. Lassay? Mr. Cotton or Mr. Eichhoff?
no, I'd just like to discuss the mechanics of it with the court, please. We can do it off the record. Or
Okay. All right. Anything else before I can get that jury started deliberating in the other courtroom?
No, no, not from us.
Okay. All right. Thank you. We're in recess.